Hello, everyone, and welcome to Thursday Talks with Chugh. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chugh, attorneys and CPAs tuning in from our San Diego office, and we are particularly honored today to have with us our founder and managing partner, Mr. Navneet Chugh. He founded our firm 38 years ago, so please join me in welcoming Mr. Chugh from our headquarters in Los Angeles. Hi there, Mr. Chugh, and welcome.
Thank you, Arianna. Thank you very much.
Thank you for being here. For today's topic, we will be talking all about M&As. If you have any questions on mergers and acquisitions, please comment them below or email us anytime at info@chugh.com. Let's get started, Mr. Chugh. So what initially attracts companies to consider mergers and acquisitions as a growth strategy?
So for most companies, a lot of companies set up and start companies so they can exit with a clear goal on day one that they're going to start a company and grow it a lot and then sell and then sail into the sunset and enjoy life. Some companies, the founders have been running it for many years, and so they're getting older in their 50s and 60s and 70s, and they want to use that as an exit. And some companies, while they're growing, they'll get an offer from another company, either for a technology merger so that they can both use each other's technologies, or usually a bigger company that uses M&A for growth. So most big companies have a growth mindset of we want to grow 10%, 15% every year. And then 3 years go by and they're supposed to have grown 45% and they haven't, and they're only grown 25%. So they quickly want to do a M&A transaction to fill in the gap and grow inorganically. So those are the reasons for the M&A transactions. Sometimes it's partners fighting that results in them saying, okay, let's get out of this and move on in life.
So it sounds like it can be quite beneficial to companies to consider an M&A. So what key factors should every company first consider before even thinking about entering an M&A deal?
So it's a very good point and a question. So often I tell clients that engage in an M&A transaction, and talk to a potential buyer or a seller, even if you don't want to sell. Because what happens is when they engage in the conversation, they learn a lot. They learn so much about their own business that they didn't know. So for instance, a buyer will come in and say, show us your books. And then they look at the books and then they'll say, well, why are you doing this and why are you not doing that? And you want to invest $1 million in this new product and new project, new building. What is the return on it? And aren't you better off doing this or better off doing that? It's like when you're trying to sell a home and you have $50,000 for improvement. Do you want to put that money in the front porch, front yard, or backyard, or kitchen, or do you add a bathroom, or do you add a swimming pool? So you can go to Google and say, I want to do $50,000 of home improvements. What gives me a better yield? And you'll find an answer. So similarly, the buyers will start saying, well, if you put in the $1 million on this project versus that project, it'll have a better yield. And the buyer, like us, would be more interested in you doing X and not Y. And then they have conversations about, do you have a partnership agreement? Do you have a shareholders agreement? Are you filing state tax returns? Oh, 30 years ago, we were doing this merger and this big company comes in and looks at this target they're going to buy. And they ask the target, are you filing state tax returns? And the seller is like, what state tax return? And if you're doing business in other states, you're supposed to file a tax return in those states. And they hadn't been filing, so they call us and say, hey, can you fix us and get us M&A transaction ready, clean up our books, issue the stock certificates, do the board's resolutions for the last 10 years if you haven't done them, and do a shareholders agreement, do the state tax returns, and clean us up. And then whether the sale happens or not, at the end of it, if the sale doesn't happen, our clients always tell us that thank you so much for putting us through this process. We learned a truckload.
So a lot of things are brought to the surface when you're going through this process. That sounds pretty helpful for both the potential buyer and the company itself. So if somebody is thinking about going through this process, how long should they expect this whole process to take? What's the typical timeline for an M&A transaction from initiation to closure?
Right. So it happens over a spectrum. Sometimes it happens really fast and quick, and sometimes the buyer has motivations that the deal must, and it's November and they want the deal closed by December end because they want the revenue added to their revenue or whatever they want to do. And normally it'll take 4, 5, 6 months, a couple of months of courting and getting to understand, for the buyer to understand the seller's business and for the seller to feel comfortable. So it's like an engagement process. And then once the dating stops, the engagement happens with a letter of intent or MOU, LOI or MOU, MOU being Memorandum of Understanding, that, hey, this is our arrangement. So that fighting over the LOI will take a couple of weeks, sometimes 2 years, but usually a couple of weeks. And then both the seller will have to disclose their books. And then we go through a phase known as due diligence. The buyer will want to see everything, the corporate records, the tax records, the financials. They will want to talk to customers. They want to see the contracts. They want to see the revenue stream of the last 3 years and financial statements. And usually we get a due diligence checklist that runs into 100 pages. And then we have a fight over what is it that we're going to give and not give, and this is not necessary. So the due diligence process lasts a couple of months. Then the buyer will prepare a contract for purchase. Sometimes it happens simultaneously, but we get a contract for purchase, and then we review that. Then we get employment agreements, then we get NDAs, and then we get a whole bunch of other documents. Then if there's many partners involved, then the buyer wants to talk to the partners, and then the partners have to review the documents. So that takes another couple of months. So usually 6 months.
Okay, so we can expect around 6 months, but it's flexible. That's good to
Yeah.
know. So how does one decide on a deal structure? Stock purchase versus asset purchase? Which one is better, and how do we know? How do we decide?
Right. So that's the $64,000 or the $64 million question in every M&A transaction. So it all kind of depends on what the seller's current state of corporate structure is. If it is a C corp versus a S corp or an LLC, the S corp and LLC are similar, largely similar. So the differences between a C corp and the other two. The C corp, if the seller sells the assets, then the seller has a potential of double tax. So if the seller's business is stuck's a bad word, but housed in a C corp, then the seller is better off selling the stock of the company, the ownership document of the company, rather than the assets of the company. And that's sometimes not a preferable thing for the buyer because they want to write it off and it makes their life a little harder. So the seller always wants to sell the stock, which is a stock purchase agreement. The buyers usually always want to do an asset purchase agreement. And sometimes the buyer will even say that we'll give you 25 million if you agree to do a asset purchase, but if you want to do a stock purchase, then we'll give you 23 million and we want a 10% discount or whatever. So those are things we bargain. And if it's an S corp or an LLC, then it doesn't really matter if the seller is doing an asset purchase or stock purchase. Then we just yield to the buyer and buyer's tax situation. What is it that they want?
So it sounds like it can be a little conflicting with both parties wanting different things. So it sounds like a great idea to hire an M&A lawyer if you're thinking about going through this process. So if you do have questions on this, please comment them below or email us at info@chugh.com. We would love to help you out. So Mr. Chugh, you've been doing this for over 30 years. What are the most common mistakes companies make during the M&A process?
Every step of the way, either the buyer or the seller is making a mistake. And after that, they look back, they're like, why didn't we do this? Why didn't we do that? So I think the first not so good thing both parties do is not try to understand each other's businesses. And everybody's very optimistic about an M&A transaction. So that's probably the first error in this whole thing. The buyer is super excited. They get to buy another company. They get more revenue. They get more employees. And the sellers are excited because they get money and they finally get to go on this world cruise that they've been wanting to go and take a 3-month vacation. And so there's tremendous excitement. Like in a normal human relationship, excitement while there's dating going on and engagement, and then the reality sets in. Unfortunately, the worldwide track record of all M&A transactions is not the best. Like a lot of transactions don't work out. Some people go to the extent of saying that 50% of M&A transactions don't work out for XYZ reasons. It is a landmine every which way. From the seller's point of view, if there are 2, 3, 4, 5 partners, one partner wants to sell, the other one doesn't want to sell. Maybe the majority partner who owns 50, 60, 70, 80% of the company wants to sell and is older, and the younger ones are like, hey, we got into this business thinking we'll grow this business and we'll make a lot of money. We're exiting too soon. You're making money. We're not. So unfortunately, one of the bad things that happens in some M&A transactions with a lot of partners as owners is that it creates a disparity, and the interests and motivations are not aligned. And so some trouble starts between the partners at times. And sometimes the trouble goes to the extent that by the time the transaction is going on and the due diligence is going on, the relationship sometimes gets so bad that they have no choice but to sell. So if that ever happens, then the smart thing to do is to keep the dirty laundry inside the house and not hang it out. Because when you hang it out and the buyer comes to know that, hey, we're buying this business and there's 7 partners and there's a fighting going on, the minute the buyer comes to know, the next day you get a call from the buyer saying, hey, we were going to buy you for 100 million, but we're having a second thought. We now only want to offer 50 million. And then we're the lawyers, we get the call saying that we're reducing the purchase price in half. And so then you call your clients and say, hey, your 100 million's gone and it's now 50 million. And everybody's like, what happened? And what happened is somebody leaked the information to this buyer. And now the sellers don't even get along. Now they don't have a choice. And now the 7 people will sit across a table from each other and say, okay, we were getting 100 million, we're getting 50 now. And the logical thing to say is say no and move on and continue doing business together. But now the 7 of them look at each other and they're like, no, I don't want to be in business with you. You showed your true colors last week when we had this meeting, and then they have to sell, and the buyers take advantage, rightfully so. And so that's where the troubles start. And then after the purchase happens and the buyers have issues that the 7 sellers said they would stay, now one person doesn't want to stay, and the buyers usually want to buy a business primarily for the employees. And if the senior experienced employees don't want to stay, then the buyers have issues because now who's going to handle the clients and the revenue might suffer. So you name it, there's endless issues.
Wow, that sounds like it can be a pretty complicated process. So, being that you're both an attorney and a CPA, what is one legal hurdle that's often underestimated in M&A deals that you've seen?
So I think when it's preparing the bride, so when somebody wants to march on to the M&A transaction and some company wants to sell their business, they have to clean themselves up, go back 3, 4, 5 years, make sure you have employment agreements with your key employees, make sure you have a stock option plan because most companies are always thinking about it, and 99% of them or 80% of them don't actually roll it out, or it's sitting in somebody's drawer to be rolled out, and everything is done. The lawyer's been engaged. We prepared the stock option agreement. We prepared the stock option plan. We've sat down, had endless meetings of which employee is going to be given what option and what is the price, and then the topic ends, but the company will never roll it out. So the stock option agreements and the stocks should be rolled out to employees. Sometimes if you do it a year in advance, then they can get a capital gain treatment upon the sale, which is tax reduction of 50% saving in tax from ordinary income to capital gain. And then the corporate books should be in order. Intellectual property should be taken care of, the trademark and the copyrights and the patents that the sellers have been thinking about filing and talking about filing and paid lawyers to do half of the work. All of that should be finished. Stuff that normally should be going on and done properly and accurately to begin with, but business takes preference, revenue takes preference, employee complaints take preference, creating a culture takes preference, paperwork doesn't take preference. But if you're going to prepare the bride for or the groom for the M&A transaction, then we have to clean up the house. Corporate tax, litigation, if there's 20 lawsuits going on, try to settle half of them. The other side wants 10,000 and you're offering them 5,000, settle at 7,500, get out. Because the buyer's going to come in and they're going to see 20 lawsuits. And then they're going to ask 100 questions. Then they're going to want to talk to lawyers. Then they're going to want to see the complaint and the answer. And all of a sudden, the attorney's fees in just complying with the buyer's request is going to be more than what you would have paid had you just settled. So cleanup of intellectual property, and the shareholder agreements and the partnership documents, all of that should be cleaned up. And then when the buyer comes in, and the buyers, when they come in with CPA firms, they come in with corporate lawyers, they come in with litigation lawyers, they come with immigration lawyers, and they ask for 100 things. And very soon they have a better idea of the seller's business than sometimes the seller has.
Those are all great points. It sounds like it's really important to make sure all of your affairs are in order before even considering this process. So make sure if you're watching this, you have trusted attorneys on your side helping you out with this process. It is very complex and things can go awry very quickly. So make sure you have a good team on your side. Mr. Chugh, let's touch on cross-border transactions. Are there any specific regulatory issues that companies should be aware of during cross-border M&A transactions?
Yes. So US is probably one of the easiest countries to do business in. And when foreign companies come to US to buy, uh, there's very few hurdles. Only if you're dealing with defense or very specialized technology that US has earmarked. Uh, Otherwise, there's very few restrictions for the buyers to come in and take over a business. That's not necessarily true of the other 192 countries in the planet. A lot of them have a lot of restrictions. I remember the one of the first transactions I did, a large transaction we did during the dot-com boom era. India had just liberalized in 1991, and they were not a very friendly country from 1947 of independence to 1991 to foreign companies coming in and buying Indian companies because of what had happened in the past. They were fearful of foreign countries coming in. And I remember this transaction we did in 1997. It was a large transaction. And it required approval from the Prime Minister's office. And there was a organization, an agency called FIPB, Foreign Investment Promotions Board, that would okay every single foreign company buying an Indian company. So our client was a US company. We were buying an Indian company. And we had to file a petition with FIPB, the Foreign Investment Promotions Board. And we were told it's going to take 1 year. And the buyer, which is a US company, and I'm in Houston today, and that company the buyer happened to be in Houston. And they're like, we don't want to wait 1 year. What is this government approval? And I said, forget government. The FIPB organization sits in the Prime Minister's office. And I don't know if the Prime Minister was actually approving every transaction. But so we did things. The buyer said, we're not going to wait. Forget the deal if this is going to take 1 year. So we did whatever we did and came through a shortcut. And so similarly, India, for instance, has severe restrictions with the Reserve Bank of India. So we need to comply with those. Certain areas for every country, there's sensitive stuff when it comes to defense, to aeronautics, to now social media. Look at US's banning TikTok. And US, which was the epitome of open up countries and open up your borders, and everybody should be allowed to do business in every other country, and the world needs to be open. And we started this whole drama, and now we are the ones restricting it. India banned TikTok about a year ago. Probably the only country that I know of that has banned TikTok. And now US is the second country. Fortunately, the US Congress, House and Senate have passed a law that TikTok must be sold. And TikTok, under its current ownership by a Chinese company, the US government will not allow. This rarely happens. And TikTok CEO got on his social media and said, well, okay, we'll see you in court. This is the beauty of United States. Doesn't happen in other countries. Fine, the government has ruled, but that's not the end of the world. TikTok's gonna sue the government of United States and say what you're doing is not right and not legal, and it's not fair trade, and it's not in support of capitalism. And we're generating $24 billion worth of GDP in the United States. And they're going to argue in front of a judge. And the judge has the power to overrule the government of the United States and let TikTok stay in Chinese ownership. And if I had to bet today, I would say that it's 50-50. TikTok has a 50% chance that a judge will overrule the government of the United States. Not going to happen in other countries, but it'll happen in this country. So the point being that if we're involved in a TikTok kind of transaction in a foreign country, then you need to be doubly sure. And there's a lot of issues from intellectual property, from corporate, from tax, that the structuring needs to be done properly when we're involved in a cross-border transaction. Language is an issue. Very few countries are English-speaking countries when it comes to law. The 48 countries of Europe, except for England, have their own languages. And same is true of Latin America and the 50 plus countries of Africa. So yeah, it's it complicates the matter at least 5x with cross-border transactions.
Wow, so sounds like you need a really good team on your side to make sure you have everything in place for this. So I want to touch on financing options with you. What financing option do you prefer for M&A and why?
So a lot of M&A transactions, if it is a large buyer, like a Google of the world, so they have cash and they will write a check. Most transactions, I wouldn't say 100%, maybe 80%, there is an earn-out provision, which means that the seller will not get 100% of their money. So if the sale happens for 100 million, it's rare that the seller will get 100 million on day one. Usually the seller will get somewhere between 60 to 80% on day one, and the balance will be paid out in the next 2 or 3 years after the transaction, sometimes as long as 5 years, sometimes as short as 1 year. And this way, the buyer doesn't have to shell out 100% of the cash. And most buyers don't want the founder or the current management of the company that's being sold to leave. They know that the current CEO, the current owner, the current founder knows the business best, and they'd prefer that person to hang around. And they incentivize that person that, hey, if you hang around and if you meet the targets you promised when we were trying to buy you, you said my revenue this year is 80 million, next year it'll be 90, and the third year with 100. Then they say, if you hang around and you do achieve what you said you can do, then we'll pay you extra money. So all of that is called an earnout. So usually transactions, 100 million or transaction would happen with the seller will get 80 million on day one and 10 million after year one and 10 million after year two, based on certain achieving of certain metrics. The smaller companies that are not Googles of the world don't have a lot of cash. So they'll even do transactions. There is no law that you have to come in and buy 100% of the company. So if you're selling a company and you want 100 million, and the buyer may come in and say, hey, can we buy 60% of you right now? We'll pay you 60 million and we'll buy 10% a year from you, or we'll buy the other 40% 10 years from now or 5 years from now. And you grow the company, and 5 years from now, we'll pay you 40% of a much larger number because you would have doubled by then. So your 40% will become another 60%. So in essence, you will have twice X the sale. A lot of companies have deals with banks and other financing companies that will give money to the buyer to do a transaction. So a lot of Indian companies have banks that they have lined up at the back, and the banks told them, we'll give you 100 million, 200 million, 300 million to do 5 acquisitions. Tell us what you're buying, show us the paperwork, show us the due diligence document, and we'll okay it. You come up with 20%, we'll pay 80%. So there's endless ways of financing the deals.
Wow, well, thank you for sharing those insights. That's super interesting. So we are almost out of time, but I want to ask you one more question. What advice would you give to companies preparing for their first M&A transaction? What do they need to know?
First thing they need to know is majority of the times when a founder sells their company, it is hard for them to do a second startup and make that successful. Some people, a minority, are very good at it and are serial entrepreneurs and start a company, grow it, sell it, and start another one and grow that and sell it. But usually the second, third startups are not that successful. And the reason they're not is one, you're older. Second, you married and now have kids or more kids than you did the first time. Third, you got money from the first sale, and managing money is a big task. So if especially if the sale was for a decent amount and you have $30-40 million in your pocket after the sale, it's going to take 20 to 30 hours a week to manage that money. So if you're busy managing money from the first transaction, there's no time for the second, growing the second transaction, the second startup. So what does this mean? So this means that your first startup is your best bet, which means that you should grow it as much as you can and don't sell it till you have extracted the maximum potential value you can. So day one, I tell clients, figure out how much money do you want in your pocket after the sale. And if you want 100 million in your pocket, then you need to sell the company for, let's say, 150 million and pay taxes of 50 million, especially if you live in a high state tax state like California or New York or Connecticut. If you're in Texas or the 9 states that don't have state tax, then it's not 50 million in tax, maybe then it's 30. But if you're living in the high tax state, then you need to sell the company for 150, pay tax of 50 and be left with 100 million. So then now you need to sell the company for 150 million. And you have to look at your industry and what does your company's revenue have to be or net profit have to be that it'll sell for 150. So work backwards and then come up with a number. So if you're in an industry where companies sell for 10 times net profit, then your net profit needs to be $15 million for you to get 150. And for your company to have a 15 million in net profit, figure out what the gross revenue needs to be. And maybe the gross revenue needs to be 100 million and it's 50 today. Then work your tail off for the next 2, 3, 4 years. Get to 100 million, 15 million in net profit, sell for 150 and pay tax and enjoy life.
That's such wonderful advice. Thank you so much for all of your insights and your time, Mr. Chugh. I really appreciate it, and I know our audience does as well. So this does bring us to the end of our conversation. That is all we have time for today. Thank you so much, everyone, for joining us. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. Let us know what topic you want to see next, and if you have any questions or suggestions, please send us an email anytime at info@chugh.com. We'd love to help you out, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you so much, everyone, for joining us today. Thank you so much, Mr. Chugh.